एक CRP या रिविजन उन्होंने रिजल्ट किया है टिपला नीतो करके जजमेंट पार्टी का नाम नहीं था टिपला नीतो का जजमेंट को कंसिडर करते हैं उसी का फुल बेंच है 5 जजेस उसी पॉइंट से रिलेटेड उसका जजमेंट उसमें बहस है उसको जरा निकालिए समझ गए
ये तो गुलाब में
तो उनको पता है गोरे जी को पता है उसको फॉलो किए थे हम लोग
From date is for admission item 28 first April 75 of 2024.
Is this for formal admission?
Yes, sir.
So decree
Suit was dismissed.
on contest?
Yes, sir. Also, but the defendants were debarred, and some of the defendants did not appear.
Okay. FA 75 of 2024, Council for Baptism is present. He submits that the first appeal is in order. The case may be admitted and it has been issue notice to the admit, call for records from the concerned court. Issue notice to the respondents. How many respondents are there?
Total 9 respondents.
Choose speak post for which recruiters be filed within by next Monday. For additional evidence.
There is one idea on recall voucher for additional evidence. Suit was dismissed on that ground, so we have not additional evidence.
Okay. In the main appeal as well as on the individual application. दोनों पर. Post for बताइए कब रखते हैं? 1st December. Awaiting service report. Office to tax enforcement.
Item 29 contestable 717 of 924.
इसमें टाइम फिक्स है. टाइम फिक्स है. Who's for the petition? State is also. Yes, you were supposed to file an affidavit.
Yes, bring for soft fast.
For hearing under order 41 to 11 item 30 second appeal 538 of 2016.
read the last order? Have you read the last order? How the consent was recorded?
I have taken consent
From
from
whom?
Mr.
No, he has denied.
Yes, it is. Actually,
No, he denied means he denied that he did not give any consent to you. You never
Yes.
approached him for any consent. Then how did you write that consent has been given? Taken consent from other side.
so हम कंसेंट ले लिए थे उनसे प्रतीक सेन से हम दो लॉयर हैं हम नहीं समझ पाए
But on the last occasion, even Pratik Sen said to me that no consent was taken.
No consent was taken.
On the first occasion, he took consent only from the Pratik. But on the second occasion, Your Lordship, it was not informed to even Pratik Sen.
so it may be my fault.
Your fault is very serious fault. आप अपने पेंशन स्लिप पे लिख देंगे टेकन कंसेंट. How did you write? ये तो एफिडेविटेड चीज नहीं है ना, ये तो एडवोकेट का रिस्पॉन्सिबिलिटी है.
It is totally on me.
क्या करेंगे? अब वकील को हम क्या कर सकते
Your Lordship.
हैं और क्यों कर सकते
No, Your Lordship.
हैं?
हम भी नहीं
ऐसा
चाहते Your Lordship. Yes.
but at least your submission should be recorded. That is your fault.
Yes, it may be important.
Essay number 538 of 2016. Learned counsel for the parties are present. And attention has been drawn to the of the learned counsel for the appellant with respect to order dated 24/9/2025, wherein it was recorded that no consent was taken from the respondents for seeking adjournment, although in the mentioned slip seeking adjournment, consent has been mentioned. The learned counsel for the appellant has submitted that there has been some communication gap with the man, and he seeks apology from the court. The aforesaid is just recorded. That's it.
There are two IAs and one supplementary affidavit. IA number 9267 of 2024.
9267 of
2024.
2024.
This IA is with respect to
For what?
recall or modification of order.
Modification.
Yes, 14/8/2024. Order dated 14/8/2024 will be it.
तो अपडेट हो गया.
I have explained by filing this IA that all the legal representatives were already on record, are already on record in the memo of appeal as respondent number 19 to 27. All his sons and daughters have sons and daughters.
तो उनका ऑर्डर है ना, उन्हीं के पास जाना. इसको लिखो. It has to go to the same. IA number 9267 of 24 has been filed for modification of for recall/modification of order dated 14/8/24 passed by the court. Office is directed to place this case before the concerned bench after taking due permission. एक आइए हैं ऑलरेडी जस्टिस अनिल कुमार झारखंड आइए ना
File number 9267.
नहीं एक को 25 कुछ कर दिए ना ये आइए डिस्पोजल हो चुका है कहाँ पेंडिंग है ये तो डिस्पोजल हो गया कुछ नहीं पता नहीं तो हो गया सर
Then it is not abated. That was modified.
ये हम बताएंगे आपको क्या ठीक है 2016 का केस को लेके चल रहे हैं ऑर्डर हो गया आईए में उस पर फिर से बहस कर रहे हैं
नहीं हमें पास नोट नहीं था हम मिस कर रहे हैं कोई बात
मिस ऑर्डर कैसे नहीं रहता है आपके पास आपके प्रेजेंस में ऑर्डर हुआ है आपके पास ऑर्डर नहीं रहता
नहीं। दूसरा एक सप्लीमेंट्री एफिडेविट है that was filed on 9/5/2020.
नो रिग्रेट्स आपके प्रेजेंस में ऑर्डर हुआ आपका अपीयरेंस रिकॉर्डेड है दिस आईए हैज बीन अलाउड लिस्ट में भी नहीं दिख रहा होगा ये पेंडिंग
नहीं हमारे पास
आपके लिस्ट में ये पेंडिंग दिख रहा है
नहीं हम आई डू एडमिट हमारे पास नहीं है रिकॉर्ड पे इट इज नॉट नोटेड
अपलोडेड ऑर्डर है
ठीक है इस मीटिंग में दूसरा एक सप्लीमेंट्री एफिडेविट है
क्या चीज के लिए सप्लीमेंट किया
in compliance of order dated 28/3/2023.
died on 21/12/99
Yes. So there is a specific order on 28/3/2023 of this honorable court to file supplementary affidavit.
when
If-
was this appeal filed
It was filed in the year 2016.
2016 when was the appeal allowed when was the appeal decided
Appeal decided in 2004.
the
Appeal decided in 2016. Suit decided in 2004.
but in neither in the suit nor in the appeal
It was never mentioned,
it was never substituted
never substituted.
तब क्या करना
Then
आप प्लेंटिफ थे कौन थे
I was a defendant.
you were the
So there is a specific order dated 28/3/2023 of this honorable court.
क्या ये स्पेसिफिक डेट देना है
Yes, to file.
so you have filed it
So I have filed. And if my contention is correct, there is a report also that she died in the year 1999. And pursuant thereto, I have to file the supplementary affidavit, and I filed the supplementary affidavit stating there that she died on
yes
21/12/1999. Then my submission would be that the appeal itself was not maintainable as the decree was passed against dead person. Then the matter
Defendant number 13. Respondent number 13 was defendant number?
She was defendant there.
He was defendant number? Defendant number 18.
Yes.
Are you sure?
Yes.
Did she file written statement?
No.
Then क्या है इसका consequence? She did not file written statement. She did not contest the suit also.
Yes.
Did you claim any relief against defendant number 18? What was the
We are the defendant there in the suit. The plaintiff is claiming against the
What is,
defendant also.
that's right, defendant number 13, 18, if the proceeding was ex parte,
Yes. Yes.
then was any relief was claimed against defendant number
Yes.
18? What was the relief claimed against defendant number 18?
The relief that was sought for in the claim.
You see, it is not so mechanical that every defendant who would expire and not substituted the decree would become a nullity. It is not so mechanical. A person who is not participating, a person who is not filing written statement, अगर substitute हो भी जाता तो क्या करता? Substituted hears?
वो लोग अपना contest करता है,
कैसे
या
contest
क्या
करता?
करता नहीं करता.
नहीं कैसे करता contest? How? What is the mode? They will only step into the shoes of the concerned defendant.
Yes.
A person who has chosen not to file written statement and not to contest the suit.
Whether before filing of the written statement or after filing of the written
We do
statement.
not know. आप ही बताइए.
Yes.
आप ही बताइए.
Therefore, the right has accrued to the legal representatives of the deceased defendant. They would have filed written statement contesting the claim of the plaintiff.
It is not automatic. आप judgment लेंगे.
There is judgment.
Vijay, of course, there is judgment. You tell me that in all cases it will be a nullity. It is not a nullity in all cases. हम यहाँ से भी order हुआ आपको याद नहीं है. हमको याद नहीं है. आपको तो क्या क्यों ही याद है? In all cases it is not a nullity.
की ऑर्डर है, एक सुप्रीम कोर्ट का ऑर्डर है 2005-06.
मिस्टर विशाल कुमार तिवारी है क्या? उनको जरा बुलाइए.
This is the rabbit.
Judgment दिखाई है sir,
Paragraph 8.
of which did this
Yes, yes, paragraph 8 says.
ये judgment.
Yes. We think that in this case a proper inquiry as to whether there was a compromise or an adjustment of the dispute in terms of proviso to Order 23 Rule 3 of the Court is warranted. The decision in the second appeal is also a nullity since it was passed in favor of deceased appellant against the deceased respondent. So it has been held that if the judgment is passed in 100%, that is nullity. And the another judgment of this honorable court that is reported in 2005 3 JLR page 443 in the case of 2005 3 JLR 443 I think.
दीजिए.
Para 4. Para 4. That may be so. But then the question will remain whether second appeal can be proceeded with at all in the absence of response number 17, considering the nature of the relief claimed in the suit and second appeal, and in the light of the decision reported in the state of Punjab versus Mathuram 1962, indicating that there cannot be two inconsistent decree, one against deceased and one against the other. But that question can be considered at the appropriate time. But the application for implementing the legal review of deceased respondent now may please stand dismissed. Another judgment of this honorable court in second appeal 315 of 2015. This judgment, para 3. Third one. It is settled principle of law that a decree passed in favor of the party who was dead or against the party who was dead is nullity, as has been observed by the Honorable Supreme Court of India in the case of Kishan Ilyas Ramkishan versus Bihari 2005-6, para 6, which read, as rightly pointed out by the counsel for the appellant and fairly agreed by the senior counsel for the respondent, decree passed by the High Court in favor of the party who was dead and against the party who was dead is obviously a nullity. It is considered that the legal representative of neither of the party were brought on record in second.
Mr. Tiwari, you remember we had considered one order. I think we had set aside the judgment on nullity if a person is not substituted.
Yes.
In that case, I think you or the other party had also argued that if no written statement is filed, then what is the consequence? If no written statement is filed by the defendant,
Perhaps in that case, Lordship, I was not there. Because we have, Lordship, several cases I had referred in that case. That is also.
you see, we are faced with two situations. I seek your assistance in this.
Yes, yes, Lordship.
We are faced
Certainly.
with two situations. One is the concerned defendant did not participate in the proceeding was expired, right? And she died during the suit, not substituted at any stage. And second part is that her own sister was already a party and she contested. She was there.
Lordship.
Right? So the second part is that whether the interest of the deceased.
Will be taken care of by the
Yes.
sister or not.
Yes. So I think the second, for second also there is a judgment.
Yes.
Is there any?
I'll give it. Because I was reading a case, Lordship, wherein Lordship the parties did
वो
not
तो हमने set aside कर दिया था.
नहीं उसमें मेरा तो पेंडिंग अभी एक सेट असाइड है
एक set aside. वो order है आपके पास?
वो वाला भी नहीं because in that case I was not there but Lordship
नहीं
was
जो
saying
हम किए हैं वो है?
नहीं वो नहीं वो दूसरा एक डिवीजन बेंच का है उसमें है कि that was set aside and matter was remanded back to the
वो तो demand होगा ये penalty है but if neither any relief is claimed nor any decree is passed
yes
against one of the defendants
yes
and she dies and her full sister
then
is
it will
also
not have
there.
any consequences so far as
Decree is concerned.
yes
This is the principle I think.
yes that is the principle
It is
even
not,
Lordship
it is not
order 22
automatic.
order 22 rule 4 Lordship says if the person does not participate and he dies 22-4-4
Right.
if the person dies Lordship and he is not substituted then his name is liable to be struck off. That is 22-4-4 Lordship.
And the judgment cannot become a nullity.
Yes.
So for that application is required to be filed.
We'll see that.
For that application is required 22-4.
देखा उनको भी जरा CPC
हाँ.
अब डिपेंडेंट नंबर 18 का क्या रोल है? What is the nature of decree passed by the learned tribunal?
The relief that was sought for in the plain was
4-4 Lordship has the answer. If the WS is not filed, Lordship can be read.
You said WS is not filed.
It is there, Lordship.
आपने देखा?
हाँ.
पढ़ी? कोर्ट
the court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representative of any such defendant who has failed to file written statement or who, having filed it, has failed to appear and contest the suit at the hearing, and judgment may in such case be pronounced against said defendant, notwithstanding the death of such defendant, and shall have the same force and effect as if it has been pronounced before death took place.
और 3 भी पढ़ी.
Where within time limit by law no application is made under subrule 1, the suit shall
नहीं number 2 पढ़ी.
any person so made a party may make any defense appropriate to his character as legal representative of the deceased defendant.
So therefore, if the defendant does not file written statement, then his legal years will be put to the shoes only,
So now the
and he
question,
cannot take any contrary stand as compared to the original.
so now the question is, if she died before the order of ex parte hearing or after the order
Tell
of
us. You tell
ex
us
parte
whether she died before the ex parte hearing or after the ex parte hearing.
For that I have to look into the record.
तो you go and see the record. इसके लिए हम लोग क्या करें? आप जाइए inspection करिए record.
To look into the record.
अभी तो ये तो substantial question आपको कहाँ बना है? आप अपना देख के समझ के आइए.
तो पहले तो ये दो पिटीशन डिसाइड हो गए.
क्या चीज़ decide करें?
ये सप्लीमेंट्री एफिडेविट पे क्या?
Supplementary affidavit में क्या decide करेंगे? It is just a supplementary affidavit. आइए तो ये कोई decide
So
करें.
it is a fact and brought a fact to the notice of the honorable court that she died before passing of the decree by the trial court.
That's right. तो आप
And
बताइए
in
किस
view
दिन
of the
expire
judgment,
It is not automatic, sir. Please appreciate. हर एक डिपेंडेंट के डेथ पर अगर सब्स्टिट्यूशन नहीं होता है तो it is not automatic. There are certain conditions which are required to be satisfied. If there are 50 dependents in a case and there are two situations which you are confronted with, one is you have to show that what is the consequence. A person who did not file the written statement and the death is reported.
when she did not file the written statement, the right has accrued to the legal representative of the deceased defendant. And they may file.
आप ऑर्डर शीट लेके आइए कब एक्सपार्टिंग हम लोग क्या कर सकते हैं
जरा सा टाइम दे दिया जाए. और वो जजमेंट भी हम खोल लेते हैं. Relief to sue है, relief against all the defendants.
क्या नाम है इनका
इनका नाम है Hazra Thakur, respondent number 13, who was defendant number 18 in this suit.
Suit was decreed.
Suit was decreed,
Appeal.
appeal dismissed, then PC.
Did you file any petition for substitution? तो अगर आप कोई पिटीशन सब्स्टिट्यूशन के लिए नहीं फाइल करेंगे तो उनके लीगल ईयर को बिना सुने क्या करेंगे? Because ultimately those legal years are required to be substituted. तो फिर when you are the appellant before this court, you say that she has expired.
So
तो लीगल ईयर उनके
legal year को पार्टी
नहीं है, आपको आईए फाइल करना पड़ेगा उसके लिए. उनको बिना सुने तो कोई ऑर्डर नहीं करेंगे ना. जो लीगल ईयर है उनको बिना सुने तो ऑर्डर नहीं करेंगे ना. फिर डिफेक्टिव हो जाएगा ऑर्डर. जहाँ पे भी ऑर्डर हुआ है, जितना भी ऑर्डर हुआ है, नोटिस करके लीगल ईयर को सुन के हुआ. पहले उनको पार्टी बनाएंगे. अभी तो आप उनको पार्टी बनाए होंगे. अब उनका सब्स्टिट्यूशन के लिए एक पिटीशन फाइल करिए. जो भी आपको समझ आए, whatever you want to file. और जब तक वो हमारे पास उनको नोटिस करके हम बुलाएंगे नहीं तो उनको बिना सुने कैसे कोई ऑर्डर पास करेगा?
जी
राइट. तो ये जो 2023 से चल रहा है और अभी भी आप उसमें कोई स्टेप नहीं लिए हैं तो आप कब तक ले लेंगे स्टेप?
2 सप्ताह तक
इसमें लॉर्डशिप एक जजमेंट है
बताइए.
2016 वॉल्यूम 2 SCC 82 पैराग्राफ 40
2016
वॉल्यूम 2
SCC
82
82
पैरा 40
पैरा
40
ये तो फुल्ली एंड सब्सटैंशियली रिप्रेजेंटेड है इसी पर. Your estate was represented because your full sister was there on it. Your
None
full
have
sister's name, yes. आपकी sister?
No, none
That-
have appeared.
हाँ.
None have appeared.
None have appeared, but your sister was there on record. She was very much there on record.
So
She
none
was
are-
very
and
much-
this case is with respect to plaintiff in which the share is definite, share is defined. But in the instant case, what they will take their stand, whether they are claiming from one of the common ancestor or from by purchase or by adverse possession, whatever the defense they may take. So it is not clear. They have none have disclosed their defense. Therefore,
No, some
this
of the-
statement
Some of the defendants, what was the suit for?
suit
Was for
was
what?
suit was for declaration
Yes.
that the plaintiff has got a valid occupancy right, title, interest and possession over the suit. And the plaintiff has a valid and legal right to collect toll from the shopkeepers of the weekly hart held in each Saturday and annual fair.
So one of the defendants would be defendant number 8,
Yes.
who was also holding some shop.
No, I cannot say that.
No, you just tell us. What was the case of the plaintiff?
Plaintiff's
Was she also holding some shop?
हाट ऐसा नहीं, वीकली हाट लगता था सैटरडे को, जिसमें कुछ लोग आते थे। तो वो तो हाट के अगर लगता तो पूरे बाजार ही पार्टी बन जाएगा, वैसा नहीं था। Other defendants were also claiming their title by virtue of sale deed or other means. And a decree for permanent injunction be passed restraining defendant, airman, agent from interfering with the plaintiff's possession. Then further declared that the sale deed executed by Anarul Haq and Nizarul Haq in respect of the land of Kata number 6 and 99 are illegal, void, inoperative, and plaintiff is not bound by the same. So really, in this suit, there is another defendant who is a member of scheduled tribe. And for a member of scheduled tribe, if a suit for possession is filed,
तो अब दूसरा पॉइंट पे मत शिफ्ट
जी।
कीजिए, पहले इसका अबेटमेंट और इसका काम
तो अबेटमेंट का तो हम पहले उनको पार्टी बनाते हैं, वो क्या बोलते हैं, उसके बाद
ये बात देखते हैं। See, the sale deed was executed in favor of the grandfather of defendant number 14 to 19. And only defendant number 18 had executed. So defendant number 14 to 19 had common interest with respect to the sale deed.
none of these defendants have appeared.
Might not have appeared. So the proceeding was ex parte against all of them. Right? So therefore, the defendant number 4, merely because defendant number 18 has expired, that will not call for setting aside, that will not call for holding that the entire decree is a nullity in the eyes of
My submission is
who
that
never participated in the proceedings ever.
yes, at that time she was not participated, but but the heirs and legal representative of the deceased defendant who stepped in the shoes of the mother, they are equally entitled to contest the suit. They may take immediate effects, and that was to be agreed.
The learned counsel for the appellant has submitted that an affidavit has been filed in this case pursuant to order dated 23/2023, stating that Hazra Khatun who was defendant number 18 in the suit and respondent number 13 in the present case had expired way back on 21/12/1999. The learned counsel submits that since Hazra Khatun had expired during the pendency of the suit, the judgment and decree passed by the learned trial court, as well as the first appellate court, is a nullity in the example. Admittedly, defendant number 18 did not file any written statement in the court proceedings. And as per the case of the plaintiff, some portion of the suit land was sold to Darbi Mia, the grandfather of the defendant number 14 to 19, under Khata number 99. It was pleaded that the grandfather of defendant number 14 to 19, never came in possession over the land covered under the sale deed, and it continued to be in possession of the plaintiff. The learned counsel submits that the date on which the proceeding was set ex parte against the defendant number 18 would be a relevant fact. And he submits that for that purpose the records of the concerned court be qualified. He has also submitted that in the supplementary affidavit, the legal heirs of defendant number 18, in bracket respondent number 13, have also been mentioned. But an appropriate petition is required to be filed so that they may also be heard in the matter. Correct? Let the records be called for from the concerned court. Record तो नहीं आया बस ये जो judgments इस पे rely कर रहे हैं ना, the learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2005 bracket 26 SCC 300 para 8 and 9. Then order dated 24/1/23 passed in SA number 315 of 2015 and order and judgment passed by this court reported in 2004 SCC online JHAR 443. The learned counsel for the
And another
respondents
judgment
has relied upon the judgment passed by the Supreme Court reported in bracket 2016 bracket close 2 SCC 82. And he submits that such judgment deals with partial abatement and appeal. Partial abatement of suit and appeal, and has also submitted that the sale deed was executed in favor of grandfather of defendant number 14 to 19, and therefore the interest of the deceased defendant number 18, who never participated in the proceedings, was also duly represented. He has referred to paragraph 40 of the suit. आने दीजिए इसको तो डिसाइड ही करेंगे. आप पहले फाइल करिए, उनको नोटिस करेंगे,
For that time is
रिकॉर्ड भी मंगा ले रहे हैं. बस DFD मत करें.
नहीं.
बस इतना ही आपसे रिक्वेस्ट है, DFD मत कराइए.
मतलब अपीयर करते हैं, टाइम लेते हैं, हो सकता है टाइम ले सकते हैं, लेकिन DFD नहीं होना.
आपका कितना केस रेस्टोरेशन में भी चलता है? नहीं चलता है.
एक केस नहीं डिस्कस हुआ.
एक केस डिस्कस हुआ है.
एक केस
तब तो सोचिए हम आप पे कितना मेहरबान हैं.
एक केस DFD नहीं हुआ.
अच्छी बात.
डिस्कस तो
आप इतना टाइम मांगते हैं फिर भी हम आपका केस DFD नहीं करते. So I am so considerate. डेट बताइए कौन सा कब का रखें. आपका तो सब लीगल ईयर का भी डिटेल दिया हुआ है. 70 इसमें लेकिन कुछ अच्छा जजमेंट आना चाहिए.
जी.
तो जजमेंट्स आप लोग की भी नज़र में आए तो जरूर से, क्योंकि ऐसे ऑटोमेटिक अबेटमेंट इतने सारे रिस्पॉन्डेंट्स रहते हैं, एक्सपार्टे चल रहा है, कौन कब मर गया कोई बताता भी नहीं है। एंड देन 84 का सूट को हम सुओ मोटो कराने के पहले एक चीज़ और है, इसमें आप ध्यान रखिएगा, इसमें बहुत सारे सेल लीड्स हैं। डिफेंडेंट नंबर 14 to 19 का एक ही सेल लीड है ना, फिर मैक्सिमम वही अफेक्टेड होगा, बाकी सेल लीड कैसे अफेक्टेड हो जाएगा। तो ये पार्शियल अबेटमेंट का भी मैटर हो सकता है, पूरा इंस्ट्रक्शन लेके रखेंगे इस पर कि अगर मान लीजिए पार्शियल अबेटमेंट भी हम लोग मान लेते हैं तो व्हाट इज द इम्पैक्ट। दे आर अ सेपरेट एंड इंडिपेंडेंट सेल, उसका एग्जिबिट नंबर नहीं लिखा है ऑर्डर में, हमको नहीं दिया। पासओवर के साथ कंटेंट एक था,
Also case item 29 contents will 717 of 2024.
हो गया।
वेरीफाई करके इनको ही फाइल करना होगा।
सर ठीक है,
आप ऑर्डर डेटेड
कागज दे रहे इसको खाली दीजिए।
ऑर्डर डेटेड 3/1/25 देख लीजिए, आप ही के ऑर्डर में आया हुआ है ऑलरेडी। प्रेयर ए बी सी के बारे में कुछ नहीं बोले, खाली 6th रिवीजन ऑफ पे से का एरियर बोले हैं, और हम बोले हैं कि और ये 2005 तक का दे रहे हैं, 2005 तक का, हम 2012 तक का मांगे टोटल 15 लाख रुपया, एंड दैट लॉर्डशिप हैज ऑलरेडी टेकन नोट ऑफ इन इट्स ऑर्डर डेटेड 3/1/25।
अब एफिडेविट फाइल करिए ना, तभी रिस्पांस
ठीक है, हम अभी एक लिख रहे हैं, हमको ये 6 अक्टूबर 2025 के पेमेंट का डिटेल्स अभी मिला है, इसको हम ऑनरेबल कोर्ट को सिर्फ प्रोड्यूस करें, इसको पेमेंट पर लाएं।
जितना इसमें लिखा है उतना मिला है ना,
वो अभी जस्ट वेरीफाई किए कि वो मिला है। हम
चलिए दिवाली तो बन जाएगा।
हाँ, वो हम तो बोलेंगे, और वो भी हजूर के कारण ही मिला, नहीं तो
वो कम है, उसको
फास्ट
इसको
पेमेंट हुआ है तो
इसको रिकॉर्ड करके इसको हम
थोड़ा
एफिडेविट
खुश
करें।
रहिए, थोड़ा थोड़ा
इसलिए हम कुछ नहीं बोलते। और ये एक दे दे किस पे स्केल में फिक्स करके एरियर दे, वो भी तो देंगे ना, डिटेल दे ही नहीं रहे।
एक बात बताइए मिस्टर ए.के. सिंह, पिटिशनर को आपसे ज्यादा तो पता नहीं होगा, तो बस उनको ठीक से मदद करिए कि ठीक से उनको पेमेंट हो जाए।
एक्चुअली ये हमको अभी व्हाट्सएप पर मिला है, इसका
हाँ, तो
प्रिंट आउट
आप उनका क्लास लगाइए ना कि आधा आधा काम क्यों करते हैं, जो एडमिसिबल है अपनी तरफ से करके दे देना है उनको, अपनी तरफ से भी कर देना है
करेक्ट।
कि भाई ये चीज छूट रहा है, ये है, ऐसा नहीं करिए ना, क्या फायदा है इस तरह से लिटिगेशन को पेंडिंग रखने से, कोई फायदा नहीं। कोई क्लियर कट एडमिसिबल अमाउंट का ऑर्डर था कि क्या?
नहीं, look to consider all the prayer of the petitioner and pass reason order if admissible amount is payable in terms of the merger scale जो हजूर ऑर्डर पास किए गए थे, that वो मर्जर स्केल का ये पार्ट दे दी 2006 का 8 तक का, फिर 8 से मर्जर स्केल का 12 का 6 यूजीसी पे स्केल होगा 12 तक, वो 15 लाख है जो हम लिखे हुए हैं में, उसके बारे में
ऐसा करिए, जो भी इनका क्लेम, इन्होंने रिप्रेजेंटेशन दिया होगा आपको, सब क्लेम का हेड होगा इनका, जो नहीं देना है उसको रिजेक्ट करिए।
हाँ
साइलेंट मत नहीं रह सकते,
बिल्कुल
जो नहीं देना है रिजेक्शन ऑर्डर दे दीजिए, हम कंटेम्प्ट ऑफ।
करेक्ट। ठीक
ठीक है, आप भी हैं इसमें सरकार,
हमने तो दे दिया,
आप ही है सरकार।
कब मिल गया होता है, ये नहीं कुछ किए होते तो।
Content Civil 717 of 2024. Counsel for the petitioner has submitted that part payment has been received by the petitioner. Still, the grievance of the petitioner has not been replaced. Counsel for the opposite party seeks adjournment to file an appropriate affidavit with respect to the claim of the petitioner under different heads. Head-wise आप पास कर दीजिए, ठीक है?
यूनिवर्सिटी, योर लेडीज यूनिवर्सिटी,
यूनिवर्सिटी will file.
हाँ ठीक है।
Post on 1st December. The affidavit should be filed by 24th. The supplementary show cause be filed by 24th of November. Mr. Singh, head-wise.
6 से 8 का
ठीक है।
Item 31 second bit 15 of 1021.
Madam, you give your appearance. Yes. You please give your appearance. Yes.
Witness appeal, these appellants state the plaintiff in the CLT case matter and an appellant in the appeal matters. this suit was instituted under section 87 of the CNT Act, to challenge the wrong entry made in the revisional survey settlement. So in that manner, both the learned courts below, they have stated that any in this 87 suit could not be decided, as they means they have stated that due to the bar in section 93 clause 2 of CNT Act, this cannot be. This would not have
What
been
is the
decided
bar?
by revision.
What is the CNT Act?
If we can just see this judgment of the appellate violation, which is from page 22 onwards.
What is the bar under section 93? 93 too.
Yes,
What is the bar deed?
so both these sections they have been quoted violation. So this bar it has been quoted in the judgment also violation at page 11 of the judgment. Section 93. So the heading is stay of certain proceedings before Deputy Commissioner or Civil Court when record of rights finally published. So in this the relevant subsection 2 says that if before the final publication of the record of rights in such area, a suit involving the decision of any of the issues mentioned in subsection 1 has been instituted before the Deputy Commissioner or in the Civil Court, the revenue officer shall not entertain any suit under section 87 involving the decision of the same issue. So both the learned courts below have held that this bar operates and thereby this application under 87.
Where was the case pending?
There was no case pending by revision. There was only a final judgment which was of 95.
No, there must be some suit pending. So tagging suit number 185 of 95.
5,000. Yes,
Of 95.
that had been decided by revision.
No, it has been decided when? Has ignored the findings of the judgment.
Court below has held that this could not be come as a relief to the plaintiffs as it was a judgment in personam and the defendants were not parties to that suit. The
It is the
defend-
trial court judgment. The revenue court's judgment.
That is on page 50 on the
मामला प्रक्रियाधीन है, but case was pending. It was not maintained.
in this, if just this 93 means in relation, it is said if before the final publication. But in this, the final publication had already been made by revision.
When was the final publication?
Usually stated that this RS survey segment publication was made on 31/8/2007.
It was finally published on 31/8/2007. When was the suit filed? 2005. So it is before final publication.
No, Bishop, this present suit, it was filed in
No,
2008.
not this present suit. The connected suit, the related suit, was pending since 2005.
My Bishop, the suit which we had filed, the plaintiffs, that was of
No, whatever you
1995.
might not have, anybody might have filed. But the point is that title suit number 59 of 2005 was pending.
Yes, my Bishop,
Then-
that the defendants had filed.
Whosoever has filed it, there is no point of law involved. Title suit number 59 of 2005 was pending. Correct? Essay number 15 of 2021. Heard the learned counsel for the appellant. This appeal has been filed under section 87 with bracket 2 of the Tobacco Tenancy Act 1908. Against the judgment dated 21st of October 2020, passed by the late Principal District Judge Dhanbad in Civil Miscellaneous Appeal number 4 of 2017. Whereby the learned First Appellate Court has been pleased to dismiss the appeal. The suit was decided under the provisions of section 87 of the Tobacco Tenancy Act by order dated 2012-2016 passed by Assistant Settlement Officer Dhanbad in CAT case number 1263 of 2008. The suit was dismissed on the ground that in connection with surrender deed arising out of the property, the title suit number 59 of 2005 was pending. The learned counsel for the appellant, while assailing the impugned judgments, has submitted that section 93 of the Tobacco Tenancy Act is not applicable as the suit is required to be filed prior to final publication of the record of rights. This aspect of the matter has not been properly considered by the learned court. This court has gone through the impugned judgments and finds that the final publication of record of right was made on 31/8/2007. And the original suit number 59 of 2005 was pending as is apparent from the order passed by the learned settlement officer by rejecting by holding that the suit was not maintainable by referring to section 93 bracket 2. This court finds that both the courts have rightly held that the suit filed under section 87 was not maintainable by referring to section 93 bracket 2 of the Tobacco Tenancy Act. This court finds no substantial question of law involved, which is this appeal is not dismissed.
2nd April 19 of 2021.
In this matter, the parties have arrived at a compromise. And
कॉम्प्रोमाइज हो गया है
इसमें हम लोग
लोग का जो
prepare किए।
सिग्नेचर बाकी है इसलिए 4 वीक कट ऑफ द
क्या मैटर?
Initially plaintiff filed the suit for cancellation of the sale.
Same.
All the parties are appearing. एक के अगेंस्ट में अवेट भी करना
She is right, but subsequently,
I
initially.
am on behalf of the intervener and I am one of the purchasers.
Purchases subsequently.
आपके साथ कॉम्प्रोमाइज हो गया है?
मतलब
आपके साथ कॉम्प्रोमाइज हो गया है?
जी।
हाँ मेरे साथ और बाकी सबके साथ
ये जो अपील अवेट कर गया इसका क्या होगा?
She has died issueless.
Issueless.
She died issueless.
Issueless.
तो ये कहाँ से पता चला?
Because we were the step son and daughters of that lady. And therefore,
Step son and daughters.
Ravi Mahato was the son of the second wife of the husband of Kasni Devi. So she died issueless.
Jhansi Devi was first wife.
Madam.
And
And we were the son and daughters, 2 to 8, that's son and daughters of the second wife.
A suit was filed by the plaintiff husband of the Jhansi Devi.
कॉम्प्रोमाइज बहुत लग नहीं रहा, समझ में नहीं आ रहा।
We will be filing an
Yes,
interlocutory application.
ये वाला जो यहाँ अबेटमेंट का ऑर्डर हुआ है ना, इस ऑर्डर को मॉडिफाई नहीं करना ये ना, तो डिलीशन का पहले ये अबेटमेंट वाला ऑर्डर कॉल करके उसको डिलीशन का पे दैट शी डाइड इशूलेस विदाउट एनी
We will be filing an application for
उसके
modification.
बिना ये कॉम्प्रोमाइज कैसे चले?
So first
ये
we will be
रिकॉर्ड पे
filing,
तो आया नहीं है, साथ ही साथ आपको करना है।
we'll be filing a modification application before the concerned bench.
कंसर्न बेंच के पास इसको तो
We'll be filing in this application itself.
इसी में फाइल करना है।
हाँ, इसी केस में.
सेटिंग असाइड अबेटमेंट करके फाइल करना है।
Riding out of the same judgment and decree, another second
second
appeal
appeal
is pending for this honorable court. Milord, second appeal number 01 of 2020. Maybe
उसमें भी
tag
कॉम्प्रोमाइज कर रहे हैं,
same
Same
party.
Same party.
Maybe
उसमें भी
tag.
ऐसे अबेट हो गया है।
हाँ,
उसमें भी
अवेट हुआ.
उसमें भी हम इंटरवेंट किए
इनका intervention.
आपका इंटरवेंशन है ना,
Allowed.
मतलब मेरा मेड पार्टी। उसका क्या डेट है? देखिए तो सेकेंड अपील 1 of 2020 का डेट। इट इज अराइजिंग आउट ऑफ द सेम जजमेंट।
Same judgment.
इसका नेक्स्ट डेट बताइए। सेकेंड अपील 1 of 2020। आउट ऑफ लिस्ट। बट कब रख देना टाइम?
4 weeks time.
आप ही लोग उसमें भी एडवोकेट्स हैं।
हाँ, उसमें भी.
Essay number 19 of 2021. The learned counsel for the parties have submitted that the matter has been settled out of court. A joint compromise petition is required. They submit that arising out of the same judgment, another second appeal, bearing number 1 of 2020 is also pending. In that case also no substantial question of law has been framed, but the matter has been compromised. Correct? With the consent of the counsel for the parties, बताइए कब रखें?
नवंबर में
4th and 3rd November.
3rd वीक
17. तो देख लीजिए, समझ लीजिए कि उनका अबेटमेंट का कैसे आप डील करेंगे। आपको अगर आपको लगता है कि कुछ फाइल करना है देखिए, नहीं लगता है तो कोई बात नहीं। कॉम्प्रोमाइज अगर डिफेक्टिव रहेगा ना तो 1 मिनट में खत्म हो जाएगा। नहीं 17 उनके जो स्टेप सन्स हैं तो आप ऐसे ही ना बोलेंगे that she has died issueless, right? But the legal heirs and successors are already on record, being the step sons. And step तो हम लोग बोलते हैं, बच्चे तो वही बच्चे होते हैं ना, not through her, but if she is the wife of a particular person, उनके बच्चे तो फिर उनके बच्चे हुए ना, हाँ? ऐसे आप नहीं बोल सकेंगे कि कोई हियर नहीं, हियर तो होंगे जरूर।
सारे हैं जो भी हैं यही पे
हाँ, बोलेंगे ना उसमें that they are already on record.
फर्स्ट वाइफ है ये गलत बोला है, ये फर्स्ट वाइफ के है लीगल है, और ये घसनी देवी जो है वो है सेकंड जिनका डेथ हुआ है।
जिनका डेथ हुआ सेकंड
Second
वाइफ है,
wife है।
ठीक है, उनका डेथ हो गया सेकंड वाइफ है, उनके मरने के बाद
हाँ उनका
अरे उनके कोई इशू नहीं है तो उनके हस्बैंड के तो इश्यूज है ना।
हस्बैंड फाइल किए थे केस, तो वो ऑलरेडी ऑन रिकॉर्ड है।
हाँ तो वो आपको बोलना पड़ेगा that the legal heirs are already on record.
ऑलरेडी ऑन रिकॉर्ड।
कि merely because a woman dies issueless that does not mean कि उनके कोई legal heir नहीं है, है ना?
नाम डिलीशन के लिए दोनों में फाइल।
हाँ एक छोटा सा पिटीशन फाइल करना है और कॉम्प्रोमाइज पिटीशन में भी लिख देंगे कि appropriate petition has been filed for deletion of
Order Saturn 13 2nd April 40 of 2005.
okay?
Your Lordship, in the previous order, the NCR record was called for, but still it hasn't been from the.
Sorry?
The NCR was called for from the principal, learning principal and district judge, but still it hasn't.
ये लेटर आया है वहाँ से, क्या चीज़ का लेटर?
The record for title appeal has been set, but still the title appeal has been kept.
टाइटल सूट का रिकॉर्ड इज ट्रेसलेस, क्या करना आपके पास है?
No.
क्या सब्सटैंशियल क्वेश्चन ऑफ लॉ है? रिकॉर्ड की क्यों जरूरत है बताइए? व्हाट इज द सब्सटैंशियल क्वेश्चन ऑफ लॉ?
Three substantial question of law has been taken. Whether the judgment and decree of the learned first appellate court is appreciated for the findings of the learned trial court and not holding the suit as barred by absolute party on the ground that Kisto Murmu was married in the Jamai form of marriage at Mauza Harishchandrapur was already decided in title suit number 4 of 1956, whereas in fact the issue in the earlier suit before the deputy collector Sahibganj in title suit number 4 of 1956 was with regard to the Rajamai form of marriage of Matla Murmu, that is the father of Kisto Murmu. The second substantial question of law was saying that whether the judgment and decree of the first appellate court are also vitiated for the reasons that the learned first appellate court himself held that the marriage of Matla Murmu was my form of marriage, and then the learned first appellate court could not have held that the Pushpa Murmu was married in the my form of marriage at village Harishchandra. Especially looking at the different DW1 and DW2 and DW5 and several documentary evidence, especially the exhibit E. The third one was whether the judgment and degree of the learned first appellate court are bad in the eyes of the law, in not meeting the reasonings of the learned.
You are the plaintiff or the defendant?
We are playing.
Who is your senior?
Mr. Rahul.
Mr.
Rahul Kumar.
कौन? 69 का आपका जन्म हो गया था 69 नहीं हुआ था उस समय का सूट इसको डिसाइड करना if the records are not necessary then we can decide it normally it is on substantial question of law DW1 ये जो एविडेंस की बात इसमें कर रहे हैं वो उसकी एविडेंस की कॉपी आपके पास है?
We have the evidence of the oral documentary evidence we have, but for the exhibits we have.
Okay, you don't have the exhibits. लेकिन exhibit के बारे में कौन सा substantial?
Exhibit E especially.
Just a minute. The title suit number 4 of 56.
No, it was the previous type suit that has been happening. It is related to that, but mainly the title suit of 2 of 1969, and then later it was.
No, it is referring to the decision in title suit number 4 of 1956.
Yes.
Decided by whom?
Districts.
देखिए हमें क्या चीज़ की ज़रूरत है इसमें oral evidences की ज़रूरत है. Exhibit E is the decision in title suit of 4 of 1956. Correct? ये तो हम लोग मंगा लेंगे. इसका रिकॉर्ड मंगा लेंगे उसमें. उसका जजमेंट एंड डिक्री मंगा लेंगे. वही एग्जिबिट हुआ ना. उसका जजमेंट डिक्री मंगा लेंगे और ये ओरल एविडेंस हम लोग कंसीडर कर लेंगे तो हो जाएगा ना. बुलाएं मिस्टर तो जरा पूछते हैं पॉसिबल है. When the records are not traceable, you will have to file an affidavit petition to call for the certified copy or the judgment copy of the judgment. आ जाएगा मीडियस ड्यूटी का टाइम तो देखना है, पार्टी पोजीशन देखना है, इशू डिस्प्यूट देखना है. कहाँ है मिस्टर राहुल गुप्ता? घर चले गए? आप बुलाइए. सीनियर लोग घर चले जाते हैं, ऐसा है क्या? बुलाइए उनको. इतना पुराना सूट और ये सब को इस तरह से पेंडिंग रख नहीं रख सकते.
Item 14, second appeal.
Other side कहाँ है? Respondent. Who is for the respondent? Are they appearing or they are not appearing? Gautam Kumar Singh.
Item 14, second appeal 374/2025.
Madam is lawsuit. IEA for substitution. Of respondent number 9, 17 and 18.
तीनों पे एक पिटीशन फाइल करते हैं.
Madam,
कब कौन बना?
I have stated in my petition lawsuit IA number 10013 of 52.
हाँ बताइए ना पिटीशन पढ़ी.
Para 2 mine. I have stated your lawsuit. Respondent number 9, namely Naresh Yadav, son of so and so died on so and so. Then para 3 mine and para 2, 3 and 4. I have stated.
IA number 10013 of 25. This petition has been filed for substitution of respondent number 9, the bracket expired on 26/25, 17 expired on 14/3/25, and 18 expired on 1/2/25. With a prayer for continuation of delay in filing the petition for substitution and also for setting aside abatement. Issue notice to the proposed legal heirs and successors of the respondent number 9, 17 and 18 for which requisites and this repose be filed within a period of 1 week. Office to tracks repose delay
2 weeks also play
2 weeks. ये कब का है केस?
2005
आपको 2
Subdivision
हफ्ता
admitted.
नोटिस करने के लिए आपको 2 हफ्ता चाहिए।
बहुत सालों में
नहीं बहुत साल हो गया तो क्या हो गया? और कंटेस्टेड केसेस को ढंग से नोटिस करिए। ठीक है? 1 हफ्ता बहुत है। Office to track speed post delivery, post on first on 10 November, awaiting service. Excuse me, please come. इसमें 17-18 बोल के कोई रेस्पोंडेंट नहीं है? 17-18 रेस्पोंडेंट का नाम बताइए। कौन है रेस्पोंडेंट नंबर 17 एंड 18?
वैसे मैं नॉट respondent number 9, 17, 18 as per online reports.
17-18 बाकी नहीं है तो कहाँ से किसको सब्स्टिट्यूट करें?
8, 9 है original जो है 8, 9 then thereafter other legal error which is substituted by earlier substitution petition then number your lordship 17, 18.
ऐसा करिएगा ना रेस्पोंडेंट नंबर मत लिखिएगा सुन रहे हैं? रेस्पोंडेंट का नाम लिखिए। आपने आगे में नाम लिखा है?
मैं
बताइए कौन क्या क्या है आगे में?
9 का लिखिए respondent number 9 नरेश
आपके मेमो में तो ये सब है ही नहीं, बाकी नहीं है कि क्या है किसको सब्स्टिट्यूट करना है? नेमली नरेश यादव।
मैं
नरेश
यादव
महतो है, नरेश यादव तो नहीं।
then my lord
नरेश यादव तो इसमें है ही नहीं।
नरेश यादव
6 नरेश यादव नहीं है, नरेश महतो।
मैं
तो महतो को यादव कैसे पढ़ेंगे हम?
alias
कुछ उपाय लगाइए कि नरेश को हम महतो पढ़ें। नरेश यादव, उसके बाद 17 केशव यादव।
केशव यादव
केशव यादव कहाँ
original
है?
respondent number 9
महतो है, यादव नहीं है। और ये है गोना महतो।
18
गोना महतो। डिफेक्टिव पिटीशन है। गोना महतो एलियस
जूना सन ऑफ धोता
ये एलियस नेम कहाँ से लेके आए? एलियस कहाँ से लेकर?
वो आधार कार्ड
यहाँ से यहाँ आधार कार्ड चलेगा, से नहीं चल सकता, आधार कार्ड नहीं चलता यहाँ पे। इतना सीनियर हो जाते हैं, इतना दिन का प्रैक्टिस है, कहाँ से किसको सब्स्टिट्यूट कर देंगे? फिर से लिखे तो आई नंबर 10013 of 2025 in essay number 374 of 2025. This petition has been filed for substitution of Naresh Yadav, Naresh Yadav, Keshwar Yadav, and Bona Mehto, alias Juna Mehto. These names do not match with the cost item. Counsel for the appellant seeks settlement. ठीक करिए इसको, ऐसे नहीं कर सकते, इसको ठीक कर लीजिए, स्पेलिंग मुझसे बुला के ढंग से एफिडेविट करना, स्पेलिंग सब देख लीजिए क्या क्या फाइल देखना बोल।
Item 15, second appeal 9 of 2010.
Substitution sold appellant died on 8 March 2021. Name is 85 years. 7 daughters, deceased ones.
क्या बोलना?
So no provision of law for the abatement has been given for civil.
Sorry,
Abatement का जो provision of law
रेड नहीं किया ना, सेटिंग असाइड अबेटमेंट का रेड नहीं किया ना, डिले सब तो किए हैं।
Yes, under section. Under order.
सेक्शन इतना सेक्शन खोजिएगा तो हर एक पिटीशन में हमको डिस्मिस करना पड़ेगा यहाँ।
Lordship, one thing more, Lordship. In this case, the respondent has also died, Lordship. Sole respondent. I had sent a letter, and that letter has come by writing the क्या प्राप्तकर्ता भर गए हैं, ये वापस आ गया मेरे पास।
तो आपके पास कोई इंस्ट्रक्शन नहीं?
नहीं, कोई इंस्ट्रक्शन नहीं है। फिर हम लेटर भेजे हैं कि कम आफ्टर रिसीविंग द लेटर, अगर आ जाते हैं तो हम डिटेल डाल देंगे।
एक ही रिस्पॉन्ड?
हाँ, सो respondent.
तो उनको सुन के ही करेंगे, उनके सब्स्टिट्यूटेड लीगल यूएस को सुन के करेंगे ना, और ऐसे कैसे करेंगे?
मेरा प्लांट भी मरे हुए थे, हम किसको
तो उनको बिना सुने आपका कैसे अलाउ कर दूँ? उनके लीगल यूएस को सुन के करेंगे, आप भी कर दीजिए। आई नंबर 9598 of 2025 in essay number 9 of 2010. This petition has been filed for substitution of sole appellant, who is said to have expired on 1/5/2021. The counsel for the respondent has submitted that, sole respondent has submitted that he had written a letter to the sole respondent, and the same has returned back by saying that the sole respondent has expired. He submits that the matter be adjourned so that appropriate steps be taken. He has also submitted that the substitution of the appellant be considered once the sole respondent is substituted. चलिए कब करें? Post on 30th October. तो सोल रेस्पोंडेंट जो डेट में, तो आपका वो 10A में पिटीशन फाइल करने हैं, तो फिर एप्रोप्रिएट स्टेप्स इनको भी तो लेना पड़ेगा, है ना? या प्रेयर करेंगे कि यहीं से सब्स्टिट्यूट कर देंगे, तो दोनों का सब्स्टिट्यूशन अलाउ कर देंगे, इससे करना।
जब तक आते नहीं कुछ बोल नहीं पाते।
ये भी इनका भी डेथ हो गया है, जब तक इनका पिटीशन नहीं अलाउ होगा तब तक आपका अभी कैसे ये सब्स्टिट्यूशन फाइल करोगे, है ना?
Item 16, second appeal 189 of 2020 and with item 17.
Notices were issued to respondent number 8 to 11 notes. 8 and 9 notes have the service report says it is unserved as not residing in the given address.
8 and 9.
8 and 9. 10 notes it says that it has been informed that she has died as informed by her son Mukhtar Qureshi, and note so far as 11 is concerned, it is also not found. So notes 8, 9 और 11 पे notes fresh notice जाएगा, 10 का substitution फाइल नहीं करेंगे.
कौन से के रिकॉर्ड में?
Second appeal 189 notes.
Second appeal 189 of 2010. Also got the appellant has submitted that notice upon respondent number 8 to 11 was issued, and as per office note, 10 has been reported dead and 11 was not found. So far as 8 and 9 are concerned, they have been served.
No, they says not residing in the given address. So not
They
fresh
have
notice.
they were also not found
Now
at the given address.
So 8, 9, 11 not fresh notice and present incorrect.
The learned counsel for the appellant prays for and is granted time till 3rd of November. 3rd of November to take fresh steps for service of notice upon respondent number 8, 9 and 11 at their present and correct address through speed post. The requisites be filed through speed post. Office to tax speed post delivery. Post on 24th November.
But there is one IA for 11324. This is for substitution of appellant number 6A. That
के करेंगे
6A no appellant का.
हाँ appellant है
हाँ.
तो within time
नहीं within time.
तो फिर बिना सुन के कैसे करेंगे?
Sir, हम लोग contesting respondent है, I don't have any.
Contesting respondent है and rest are
वो
all
जो
performed.
8, 9, 11 को है, उन्हीं का आपने
Guided
अच्छा.
and you will just see
The
the age
just a
of
moment.
the
IA number
IA number is 11324.
that we have filed an application under order 22 informing that he died.
IA number 11
324.
324. 11324 of 24 has been filed for substitution of
Appellant number 6A notes paragraph
appellant
5.
number 6 capital A
Hina Khatun,
who Hina Khatun
who died on 19/1/23, paragraph 5.
who died on 19/1/2023.
2023.
The council submits that the petition has been filed after the contesting respondent had filed an application under order 2210 capital A of CPC informing about the death and mentioning about the legal heirs and successors. The counsel for the contesting respondent submits that he has no objection so far as prayer for substitution is concerned. Considering the aforesaid submissions, IA number 11324 of 24 is hereby allowed. On delay is also condoned. The abatement is also set aside.
But in the next record notes,
The legal wakalatnama you have
हाँ
filed?
वकालतनामा फाइल.
Wakalatnama on behalf of the proposed legal heirs and successors of appellant number 6 capital A has already been placed on record. और एक आइए है
But इसपे नहीं notes, next वाला केस.
इसके साथ वकालतनामा तो नहीं दिख रहा, बाद में
इसके साथ नहीं
है।
है, बाद में. दिखाओ।
और ये कौन सा है 11455 दिस इज वन पेंडिंग नहीं ठीक है ये हो गया
ये हो गया। नेक्स्ट वाला जो है सिविल रिवीजन
ये आपका आईए क्लोज कर दें आप और भी कोई आईए पेंडिंग है इसमें
नहीं
और कोई आईए
इसमें नहीं
ठीक है दिस इज डन
यस बट सेकंड वाला जो है सिविल रिवीजन इसमें नोट्स देयर इज वन आईए दिस इज 9705 for expunging the name of petitioner number 2
expunging he has died issueless
yes
इसमें आप
paragraph 2 and 3
इसमें रिस्पोंडेंट कौन
same
आप ही हैं सर
हाँ
आर दे अपीयरिंग
I don't have any objection, of course.
देखिए आईए नंबर 9705 of 25 this petition has been filed in civil division number 26 of 22 this petition has been filed for deletion of the name of petitioner number 2 Mohammed Basim who is said to have expired issueless
yes
on
5/11/20
leaving behind no legal heirs and successors ऐसा होता है क्या एग्नेट्स
हो गए लेकिन इनका अपना है
बहुत स्ट्रांग स्टेटमेंट है
बट डेफिनेटली प्रॉपर्टी है तो किसी न किसी का इंटरेस्ट इन्वॉल्व कर जाएगा
तो सरकार के पास चले
Subject to objection होना चाहिए. Although I am not appearing.
तो क्या करेंगे
Subject to
कोई
objection if
कोई
any.
रिस्पोंडेंट किसने अपीयर किया है
Arvind Kumar Sinha, Mr. Arvind Kumar.
कहाँ है इज नॉट देयर nobody appears on behalf of the respondents and no counter affidavit has been filed to this application. Considering the submissions, the name of petitioner number 2 is directed to be deleted from the cost item at the risk of the applicant.
तो इसमें एक चीज और 12C and 12D
मोहम्मद वसीम देखे तो हमको लगा इनके तो खानदान में बहुत लोग होंगे करेक्ट इसीलिए आई डू नॉट नो कोई ऑब्जेक्शन होगा तो आप जानिए
बट 12C and 12D को नोटिस गया था उसपे नॉट फाउंड आया फ्रेश नोटिस में 12C and 12D
Counsel for the appellant has submitted that notice issued upon opposite party number 12C and 12D
yes.
has returned unserved with a note not found.
Not found not says it is not found due to big colony.
Due to improper address. Counsel for the appellant prays for and is granted time till 16th October. ज़्यादा टाइम चाहिए.
Time.
ठीक है. Till 3rd of November to take fresh steps upon respondent number 12C and 12D at their present and correct address with pin code and police station. ठीक है? स्पीड पोस्ट से कर दीजिए.
हाँ.
इसको कब रख दें बताइए.
Same tagged है.
कौन सा डेट?
24.
ये जो आप लोग इशूलेस हमको बहुत लगता है कभी कभी कि ऐसे डिलीशन किसी दिन कोई कंटेस्ट करेगा तो बहुत भारी पड़ेगा. अब आप सोचिए कौन सा केस में कंटेस्ट करेंगे.
Also, this item 13 second to 40 of 2005.
इसका जो है records नहीं मिले. If we see the substantial question of law, is it possible to decide the case?
It can be done, but the lordship, I am only afraid that whatever is the end result, ultimately it is challenged.
इसके लिए आपको petition फाइल करना पड़ेगा.
It would be better.
ऐसे नहीं करेंगे.
नहीं, it would be better. What happens that whenever record is missing, then your lordship, we can be directed, we have to file it on affidavit that this is the document
You
which was
file
there. तो उसी के बेसिस में there the records must be reconstructed.
तो ये बोल रहे थे कि ये ओरल एविडेंसेस आपके पास हैं, सर्टिफाइड कॉपीज हैं?
सर्टिफाइड
सर्टिफाइड नहीं है तो
नहीं तो अदर साइड का होगा, कोई तो निकाला होगा.
अदर साइड का तो होता ही पता नहीं. गौतम कुमार सिंह कौन है? यू नो गौतम कुमार सिंह? हम तो नाम भी नहीं सुने लग रहा, देखेंगे तो समझ आएगा.
Only single name.
देखिए, it is your appeal, right?
It is my appeal.
So whatever you have, देखिए ऐसा अनसर्टिफाइड कॉपी नहीं होने से तो हम नहीं मानेंगे. So if your the appellant is ready to do the
He was
case,
actually he had filed a proper suit, so probably he must have been supplied with the free copies by the court itself. But I'll verify. Without
वेरीफाई
verifying, I
करके इसको फाइल
don't
कर
know.
दीजिए.
Yes.
और एक इसमें सर्टिफाइड कॉपी है कोई पुराना जजमेंट का,
हाँ.
1956 का. तो अगर आगे फाइल करेंगे तो उसका सर्टिफाइड कॉपी हम लोग कोर्ट से कॉल फॉर करके मांगेंगे.
कुछ तो सर्टिफाइड कॉपी डॉक्यूमेंट का है.
जो है वो फाइल करिए.
हाँ.
एक डॉक्यूमेंट जो पुराना सूट जिससे रेस्ट ड्यूटी काटा का कहानी चल रहा है, तो उसका सर्टिफाइड कॉपी जजमेंट एंड डिक्री
उसका
का
सर्टिफाइड है. 56 है. 56. We have certified copy.
तो देख लीजिए जो आपके पास है उसको फाइल कर दीजिए.
एकदम.
ठीक है. आपने
So
कोर्ट का
if
रिकॉर्ड
your lordship would pass it over for
I
the
will pass it over.
without.
You see these old records, suit of 1969. We were not born, correct? You and me also were not born.
Yes.
Right. अब उसके बाद 56 का एक टाइटल सूट का जन्म. तो बस अब इसको
नहीं, we must do. Absolutely.
इसको जो भी आपको फाइल करना है,
ठीक है अल्लाह.
you file it. Records are not available. These are the available records with you.
ठीक है.
And if anything is कहीं घर से कोई सर्टिफाइड कॉपी अगर मंगाना है, अगर मान लीजिए उसका प्रीवियस जजमेंट का नहीं है आपके पास बाई एनी चांस, यू कैन कॉल फॉर द जजमेंट एंड डिग्री की कॉपी तो मिल ही जाएगी ना. अगर है तो फाइल कर दीजिए.
इनका बोलना है कि वो कैंप कोर्ट में हुआ था मैटर डिसाइड, सो प्रोबेबली द रिकॉर्ड्स मस्ट हैव बीन विद दुमका.
तो ये आप जाइए वहाँ डिस्ट्रिक्ट जज से बात करिए. दुमका से तो आ ही गया है कि उनके पास नहीं, दुमका से भी रिपोर्ट आ गया है कि नहीं.
दुमका से है तब तो कुछ नहीं.
दुमका से भी आ गया.
Then we'll be filing. Whatever.
आप कर दीजिए जो भी है इसको कर लेंगे डिसाइड. अब ये रेस्पोंडेंट तो अपीयर नहीं हो रहे हैं. वी डू नॉट नो दे आर अलाइव और डेड. कोई खबर नहीं है. इसको पास ओवर कर.
पास ओवर.